Justice Thomas, in dissent, writing on behalf of himself and Justices Gorsuch and Alito, stated that DACA was illegal to begin with, and that it simply should have been dismissed on that basis, that, the rescission was perfectly lawful because the law itself to begin with was unlawful, for two reasons. One, there was no basis in the INA for Janet Napolitano and DHS back in 2012 to enact DACA to begin with. Two, and this is really interesting, even if Napolitano did have that authority, she herself failed to go through notice and comment rulemaking required under the APA for the action. So it pointed out the discrepancy that Mark alluded to earlier, that there is a policy of DHS that is ruled, that is rescinded, and then the rescission is deemed to be violative of the Administrative Procedure Act when in fact the actual implementation of the program itself had never gone through the APA. Justice Alito, writing in dissent, stated that this was a prime example of everything that was wrong with the courts. That, in essence, parties had been able to suspend a perfectly legitimate rescission of an unlawful rule by going through the courts, and the Supreme Court's decision was just one more abuse of our federal system and the three branches of government, the separation of powers in doing that. Justice Kavanaugh, also writing in dissent, stated that the court should have considered Nielsen's decision. In essence, his argument was Napolitano had issued the DACA program by memorandum, that Duke had rescinded that program by memorandum, and that the statement by Nielsen was, in fact, just another rescission, and that it should have been that rescission that the court had focused on.